Welcome back to this course on copyright and related rights law. In the previous session, we had started a segment in which we are solving problems. To re-emphasize, these problems are based on real-life situations. To solve these problems would mean to use your knowledge that you have accumulated over the many sessions that we've had before. This would mean an effective revision of subject matter knowledge, originality application, exception understanding, and infringement understanding. When we look at these problems, feel free to pause the video and try and solve the problem yourself, as in any case, I will be solving it for you. Let us then come to the next problem. For the purposes of satisfying course requirements in a subject, an engineering student selects a topic. He discusses the topic with the concerned faculty. The faculty gives the go-ahead. The research takes 2 months. The work is submitted to the institution. The student wishes to publish the work, but the institution denies permission, citing that the institution has copyright in the work. Can the student go ahead with publication? Is the student the copyright owner? Let us consider the same manner in which we were considering arriving at a solution in the earlier session. What is the work? The work seems to be a literary work. Who is the author? Clearly, the author is the student who has made this research paper. Who is the first owner? There is nothing in these specific facts that illuminate any other understanding apart from the fact that the author himself is the first owner. Just because a student submits a research work as part of a course does not mean that first ownership vests with the course faculty or the institution. There is nothing in Section 17 of the Indian Copyright Act which provides for such a categorization of first ownership. If indeed the institution is claiming first ownership, then this can be on account of a transfer by way of written agreement. But otherwise, it will be the student who will be the first owner and the copyright holder over that particular expression, which in this case is a research paper. Let us consider the next problem. X is a poet. Y is X's friend. On a visit to X's house, Y found X's diary of poems. Y realized that they were unpublished. At an event where both X and Y were present, Y narrated some verses. Y gave due attribution to X. Has Y violated X's copyright? Let us consider what is the work. The work is a poem. What is a poem? Is it a literary work or is it a dramatic work? I'm sure you are all saying literary work, because the recitation of a poem does not require the need for any bodily movement or action. And therefore, we can categorize a poem, which is a written expression, as a literary work. Who is the author of this literary work? Clearly, it is X. Who is the first owner of this literary work? Clearly, again, in this case, it is X. Just because this poem is unpublished, does it mean that there is no copyright in it? Please recall our discussion on whether copyright can subsist in an unpublished work. You would remember that copyright can in fact subsist in an unpublished work. And therefore, why in having published this work has violated the copyright under section 51? Can Y claim that only some verses were cited and therefore this is not something which should amount to an infringement? Y can also say that it is not like he said that this was his work. He gave due attribution under moral rights to X. You would recollect that publication of a work is the right of the author. Once first ownership is decoded, then we know for a fact that whether publication is something that the author is engaging in, or is it somebody else who is not the author. But nevertheless, in this particular situation, because first ownership is with X, in publishing it, even if some verses, Y has infringed the copyright under section 51. And there is no exception that is provided under the Copyright Act against this particular action. Let us look at the next problem. X has published a damaging review of Y's film on YouTube. Y's film and its business takes a deep dive, takes a serious beating because of this review. Will X's review be considered as a copyright infringement? Let us first understand what is the work. The work here is the cinematograph film. Who is the author of the work? The producer of the film, which is Y. Who is the first owner? Y is the first owner. So there is nothing in this which seems to suggest that in taking substantial portions, if they have been taken by X, X is infringing under section 51. But is there any exception that can protect X's action? Do you recall our discussion on fair use? Do you remember Campbell versus Acuff Rose? Do you recollect the 4 factors that we had discussed under fair use and how we had discussed fair use and fair dealing to be very similar in their effect? You would no doubt have a very easy way of answering this question if you can apply section 52 clause 1 subclause A. What does this provision say? The following acts shall not constitute an infringement of copyright, namely, a fair dealing with any work not being a computer program for the purposes of criticism or review. We had understood in Campbell versus Acuff Rose as well that copyright is not concerned with the nature of the criticism, the nature of the review. It could be damaging. The court should not concern itself with good quality or bad quality review. Rather, the court is focused on the purpose. And herein, where the purpose is review, there is a possibility that this will not be considered as infringement. Let us look at this problem now. ABC Educational Institution is organizing a fest. All students of the institution and parents are called as audiences. Students communicate copyrighted sound recordings at the fest. Are the students engaging in violation of copyright? Let us first consider what is the work. Clearly, the work is the sound recording and the sound recordings which are being communicated. Who is the author? The producer of the sound recordings. Who is the first owner? Again, it would be the producer of the sound recordings. In case of considering whether there is infringement or not, when we look at Section 14 of the Indian Copyright Act, when we look at the copyrights that are provided to sound recording producers, the right to communicate the sound recording is a copyright. And therefore, under Section 51, this is an act of infringement. But is communication of sound recordings by students in an educational institution an exception? Let us look to Section 52. Section 52, Clause 1, Subclause J. This is how it reads. The following acts shall not constitute an infringement of copyright, namely, the performance in the course of the activities of an educational institution of a literary, dramatic, musical work by the staff and students of the institution, or of a cinematograph film or a sound recording if the audience is limited to such staff and students, the parents and guardians of the students, and persons connected with the activities of the institution, or the communication to such an audience of a cinematograph film or sound recording. You can see that Section 52, Clause 1, Subclause J provides for a clear picture on whether this particular act can be considered as infringing or not. On direct application of this provision, we can see that such a communication by students in this educational institution will not amount to infringement. We can see that our understanding of permitted acts had informed us that provisions under Section 52 which are not tied to fair dealing or such terms such as reasonability have to be seen from the perspective of purpose. The purpose then is that in an educational institution and such a setup, if communications of sound recordings are done and the audience is restricted to the students and guardians and the staff of such educational institution, then this should not amount to an infringement. The extent of usage of sound recordings or the extent of communications, you would recall, becomes an irrelevant consideration. Let us look to the next problem. An audiovisual recording of a singing performance is created by X. The lyricist is a person Z. The composer is a person Y. Sound recording is owned by ABC. X wishes to upload his audiovisual recording on YouTube. Will X be in violation of copyright with respect to ABC or Z or Y? Let us understand first what the work is that is being used. When X delivers a performance in which X is singing, X is clearly not a machine and therefore X cannot play the sound recording. What is X doing then? X is using the lyrics and the composition in singing. Therefore, the works that are being used by X is the lyrics and the composition. Who is the author? The lyricist and the composer of the respective lyrics and the composition. Who is the first owner? Now this is tricky. In general cases, wherein there is a sound recording in which there are underlying works. There is a possibility that upon agreement, the underlying work authors have transferred their entire copyright to ABC. If that is not the case, then it is possible that Z and Y are owners in their works, which is separate from the sound recording itself. Is there any exception that would cover this particular use by X of the lyrics and the composition? There isn't. In fact, if X were to upload this audiovisual recording onto YouTube, this audiovisual recording, because it will contain the unauthorized usage of lyrics and composition, it would be considered as an infringement of their respective copyrights. Let us consider the next problem. X publishes a blog piece of a certain topic. X had used an artificial intelligence tool. The tool had produced an output substantially similar to a copyrighted literary work. Is this output an infringing work? Let us first see what the work is. The work that has been substantially used seems to be a literary work. Who is the author? The author would be the author of the work whose work has been substantially taken. Who is the first owner? It could be that author, or it could be the publisher to whom the author had assigned the rights, or the publisher who was the first owner of that work. Is there any exception towards the usage of AI tools and an output which is substantially similar to an original work? There is no such exception. AI tools are known to generate outputs based on data that is fed to it. This data could in fact comprise of copyrighted material, and therefore the output which is substantially similar to the original work will be an infringing expression. Let us look to the next problem. X is an actor. X has performed for ABC film. ABC is edited to show X's performance in a vulgar animation. Is there a violation of X's performer's rights? You would recall that performers have both economic rights and moral rights. You would recall that under section 38B, it is clearly provided that any such modification which is to the prejudice of the performer and his reputation will be a violation of his moral rights. What is the work here then? It is the film. Who is the author? The producer is. Who is the first owner? The producer is. But in terms of performers' rights, moral rights are applicable independent of any assignment that is made. That is, even if the performance is incorporated in a cinematograph film and the producer is enjoying the performer rights under section 38A, section 38B will still apply. Only those modifications which are necessary for the purpose of technicality can be done and which will not amount to a violation of moral rights of the performer. The last problem we will consider is that X company is specializing in sofas and making of sofas. X's design team prepares designs which are then mass applied on sofas. Y company copies some of these designs. Can X claim copyright violation? Firstly, what is the work? the designs could be claimed as artistic works. Who is the author? The author is the person who has made such a design. In this case, it would be an individual within X's team of designers. Will Copyright Act be applicable? You would recall that artistic works are distinct from those designs which are capable of being registered under the Designs Act. Therefore, because this design is intended to be mass applied to sofas, it is ideally not protected under the Indian Copyright Act. And therefore, the right approach would be, or would have been, for such designs to have been registered under the Designs Act and for the copyright to be claimed under the Designs Act and not under the Copyright Act. With this, we come to the end of this course, Copyright and Related Rights Law. Let this be a beginning for a deeper understanding into copyright law. Thank you for joining me.